Passover case item 3 WPL 3094/2012.
Yes, Mr. Sachin Kumar is not there.
Item number 21.
Passover
Item 3
matter.
Passover matter.
आइटम के साथ बोलिए.
Yes, please.
आइटम का नाम फ्लैश किया.
Yes, please.
Who is for the respondent? Nobody appears on behalf of the parties. Goes tomorrow. In spite of repeated calls. आप हैं मिस्टर सचिन कुमार की तरफ से? क्या वो appear नहीं हो रहे? डिस्कस कर दें? No instructions.
नहीं एडजॉर्नमेंट लीगल मास्टर.
वही तो हमको समझना है कि आप चिट्ठी लिख के क्या सोचते हैं कि कोर्ट में अपीयर होने की जरूरत नहीं है. 3 बार कॉल कर दिए हैं. So you will issue a letter to the court that you want adjournment, and you will not appear in the court
No,
also.
that is not the intent.
Then what is the way?
Not
What is the way? ऐसा करेंगे ना तो आपके ईमेल को ब्लॉक कराने का कुछ उपाय करेंगे. मत भेजा करिए कोई एडजर्नमेंट लेटर.
Your Lordship, that was not the intention, Your Lordship.
So
We always appear, Your Lordship.
अपीयरेंस का बात नहीं है. आप लेटर लिख के जो है ना
नहीं,
एब्सेंट
लेटर
नहीं हो सकते हैं.
लेटर नहीं लिखे थे, Your Lordship.
लेटर लिखे थे ना.
व्हाट्सएप
और कैसे लेटर लिखते हैं आज के ज़माने में?
मेल से.
पोस्ट ऑफिस लेटर राइटिंग कंपटीशन करा रहा है क्योंकि लोग चिट्ठी लिखना भूल गए हैं. आपको मालूम नहीं है बात? यस, इट इज़ अ फैक्ट. स्कूल में करा रहे हैं. बच्चे स्कूल में पढ़ते हैं इसलिए पता है. देयर इज अ लेटर राइटिंग कंपटीशन कंडक्टेड बाय पोस्ट ऑफिस. कब चाहिए आपको?
Your Lordship, on week 16 दिसंबर वाले वीक में any.
कई बार एडजर्नमेंट हो चुका है. सोच समझ के डेट बताइए. इंस्ट्रक्शन लेके
हम ले लेते हैं, Your Lordship.
बताइए. इसको ऑर्डर मत टाइप करिए, ठीक है? और रेस्पोंडेंट कौन है इसमें? उनको पहले से खबर कर दिया होगा वो एब्सेंट है.
हाँ, उनको इन्फॉर्म करके ही.
आज के बाद से आई एम मेकिंग इट वेरी क्लियर टू यू. कोई जरूरत नहीं है कोई एडजर्नमेंट सीधे सर से देने की. एडजर्नमेंट चाहिए ना मेंशन करके दिया करिए. अदर साइड से कंसेंट लेकर.
Passover case item 7 WPC 5436 of 2018.
Yes.
From the respondent.
Where is the petitioner?
This case, Your Lordship, there is an appeal pending before the Deputy Commissioner.
Pending.
Pending. It is on the stage of hearing.
Where is it mentioned?
Your Lordship, there an affidavit has been filed. Dated 26/9/2023. Paragraph 4.
There is a supplementary affidavit also, 12/6/24. Let us see the supplementary affidavit. Paragraph 4. You say paragraph 4.
Paragraph 4. Appeal being RMA case number 50 of 2018, 19 without pass is in the stage of hearing.
against the same order which is under challenge in this case?
Yes, ma'am. Paragraph 2 in the main writ petition, the paragraph 2 is also mentioned. Petitioners have earlier moved, filed an appeal bearing RMA case number such and such before the court of this Deputy Commissioner Deogar. Petitioner have not filed any appeal.
So they have said that it is, they have filed it.
They have filed it.
And you have said that it is still pending.
Still pending.
This appeal has been filed against Annexure 3.
18/6/18 order it.
देखिए, nobody appears on behalf of the petitioner in spite of repeated calls. The
Private respondent.
wide order dated,
They are obtained the stable, and since it is an
they have obtained stay where?
from the High Court.
We will vacate it, no?
That-
They have filed an appeal. They can't have it both ways.
Yes,
The appeal we file करेंगे और
my
this we file
submission.
करेंगे.
For the stay was granted.
And they are not appearing. We don't bother about it.
Apply.
देखिए. The order dated 16/5/2024 आ गए ना? अपील फाइल किए हैं, जाके अपील परसों करिए।
अपील फाइल
दोनों कैसे चलेगा? सेम इम्प्यूग्ड ऑर्डर के अगेंस्ट अपील भी फाइल करेंगे और रिट भी फाइल करेंगे।
अपील फाइल के हम उस पर लिखे अपील जब मेरा इंक्रोचमेंट कल उसको हो चुका है
पास ओवर नॉट टुडे नहीं होगा कुछ
हम
नहीं।
चुके हम प्रॉपर्ली रेडी नहीं थे उस केस में
नहीं।
और वन देयर एप्लीकेशन ये केस पोस्ट हुआ है विदाउट माय कंसर्न, इसलिए इसको कल पर रखते हैं हम
नहीं
इसको कन्विंस करते हैं हुजूर इसमें हम कन्विंस करते हैं हुजूर हम अपने रिट पिटीशन में लिखे हैं कि अपील फाइल की है, अपील सुन करके कोई ऑर्डर नहीं कर रहा है, देन वी मूव बिफोर द ऑनरेबल हाई कोर्ट।
करवा देते हैं ना ऑर्डर। अब
तो
जाइए।
ये मेरा घर डिमोलिश कर देंगे
अब नहीं करेंगे।
और एक चीज सुन
नहीं करेंगे ना। आप
जैसे
बताइए, अपील फाइल करके आपका अपील नहीं सुन रहे, कौन डेप्यूटी कमिश्नर नहीं सुन रहे हैं?
हाँ
कौन से डेप्यूटी कमिश्नर है बताइए? डेट यहीं से फिक्स करेंगे।
हाँ, उसको डेट फिक्स करके अगर स्टे कंटिन्यू कर दिया टिल वो नहीं
वही
करे
स्टे आप बताइए ना, किस दिन जाइएगा? कल जाइएगा?
हाँ कभी भी
ठीक है।
लेकिन ये एक चीज उसके पहले थोड़ा सा सुन लिया जाए।
अब क्या सुनना है?
नहीं,
आपका
ये-
अपील
ये-
डिसाइड करवाते हैं।
नहीं नहीं एक चीज सुन लिया जाए पहले
जस्ट यू आर देयर।
एक मेरा बात को जरा सा सुन लिया
सुनाइए।
ये कह रहे हैं कि इंक्रोचमेंट है
हमको मेरिट में सुनना
नहीं
ही
सुन
नहीं है।
इंक्रोचमेंट एक लेट मी कंप्लीट अब उसके बाद आप उत्तर दिए। ये इंक्रोचमेंट है, ये 1948 में सूट फाइल हुआ, सूट इज डिक्रीज माय फेवर और उसके बाद ये 70 साल बाद फिर वो इंक्रोचमेंट का केस मेरे ऊपर ला रहे हैं। ये कहते हैं कि प्रधान को राइट नहीं था उसमें सेटल करने का, हम लगाए हुए हैं उसमें।
हम लोगों को मेरिट में नहीं सुनना है ना, आपने अपील फाइल किया है ना, अपना अपील डिसाइड करवाइए। डेट यहीं से फिक्स करते हैं। जब प्राइवेट रेस्पोंडेंट है यहाँ,
Not sir.
बस आप लोग
We
चलिए।
will appeal. That is another thing.
फिर क्या?
लेकिन टिल देन वो कोई डिस्टर्ब नहीं करेंगे जब तक वो ऑर्डर को नहीं पास करते
नहीं करेंगे। अब
ना।
जाइए।
तब तो मेरा 1936 में मेरा बिल्डिंग बना हुआ है, ये आया हुआ उसमें आरी केस 1941 में फाइल हुआ था।
अभी तक
उस
कुछ नहीं हुआ।
41 में आया हुआ है कि मेरा घर पहले से ही बना हुआ है और उसमें आरी केस में एसडीओ साहब का ऑर्डर है कि हाँ इनका घर बना हुआ है, इनको लेट देम उनको रहने दिया। उसके बाद फिर ये लोग सूट फाइल किए, सूट मेरे फेवर में डिक्री हुआ, फिर ये लोग अपील में गए।
मंडे
अपील
को
में
चले जाइए, मंडे को जाके अपीयर हो जाइए। 15-20 दिन में ऑर्डर फाइनल ऑर्डर करने का
लेकिन
order
तब
करते
तक
हैं।
ये इस डॉट ऑर्डर कोई किया जाए कि वो तब तक हमको डिस्टर्ब नहीं करें।
आप ऐसे उंगली करके नहीं कर सकते।
सॉरी
जैसे जेस्चर अच्छा नहीं है, बहुत खराब जेस्चर है ये। कोर्ट की तरफ से ऐसे उंगली कर करके आपका राइट है क्या इंटरव्यू ऑर्डर कंटिन्यू कराने का?
नहीं नहीं हम हुजूर से प्रेयर कर रहे
क्या प्रेयर कर रहे हैं?
हैं, सॉरी उसके लिए मेरे एक्शन के लिए सॉरी।
क्या क्या प्रेयर कर रहे हैं?
ये जब तक वो डिप्टी कमिश्नर वहाँ डिसाइड करते हैं तब तक के लिए वहाँ से हमको इविक्ट न करें। जब जो
ये
ऑर्डर
आपका
पास
प्रेयर है, ऑर्डर हमको पास करना है।
ना हुजूर, ये मेरा प्रेयर करना है हुजूर को, लेकिन ये जैसे यहाँ ऑर्डर जाएगा हमको
कहाँ
80 साल
लिखे है रिट पिटीशन में कि आपका केस नहीं डिसाइड हो रहा है? कहाँ लिखे है रिट पिटीशन में? दिखाइए,
हम रिट पिटीशन में लिखे हुए हैं,
दिखाइए स्टेटमेंट दिखाइए।
स्टेटमेंट हम दिए हुए हैं।
दीजिए बताइए कहाँ लिखे? सबमिशन तो किया है, लिखे कहाँ है कि आपका अपील डिसाइड नहीं हो रहा है इसलिए रिट पिटीशन फाइल कर दी?
ये इनके आया क्यों हियरिंग करके ऑर्डर पे रखा हो
बताइए ना कहाँ पर है,
हुजूर इनका काउंटर फिट देखा जाए
बताइए काउंटर में कहाँ लिखा है?
काउंटर एफिडेविट में स्टेट का जो काउंटर फिट फाइल हुआ है उसमें
बताइए कौन सा स्टेटमेंट कहाँ पे लिखा हुआ है कि हियरिंग करके ऑर्डर नहीं पास कर रहे, स्टेटमेंट से
हाँ,
लिखेंगे
वो-
ऐसा बात?
हाँ यही बात है
ये तो कितना फेयर है, कितना फेयरली लिखे हैं कि हम हियरिंग कर
5 to
ऑर्डर
5 to 5 ये बुजुर्ग दिखा दे रहे हैं
बताइए कहाँ लिखा है?
In fact, my ladyship, we have.
जय उनको बोलने दीजिए ना, अभी सबमिशन किए हैं कि हियरिंग नहीं हो रहा है, अभी बोल रहे हैं हियरिंग करके ऑर्डर रिजर्व किए हुए हैं, कहाँ से बोल रहे हैं हमको नहीं समझ आ रहा, बताइए।
कि पारा 17
पढ़िए
पारा 17 में पेज 13 आया
पैरा 17 पढ़िए।
Para 17, that reply para 17, the return application it is humbly stated and submitted that the averments made is one statement of the petitioner and as such the requires no detailed comment on that, but it has fact that the petitioner Raghunath Rai filed an appeal before the deputy commissioner Devar RM number this and this Raghunath Prasad Rai versus Pramod Rai against the ordered SDO removal inclusion. After hearing the parties, the learned deputy commissioner fixed the case for order, and order has not yet been passed by the learned deputy commissioner, and order is likely to be passed very soon. ये 19 में ही ये कह रहे हैं।
अब तो नए डेप्यूटी कमिश्नर आ गए होंगे, नया हियरिंग
हाँ तो मेरा हम्बल प्रेयर है वो फिर तो नया सिरे से सुनेंगे, फिर वो लेंगे, एक टाइम फ्रेम कर दिया जाए, उस फ्रेम में हमको भी मिले जो ऑर्डर पास करना होगा।
इन्होंने अभी 23 में भी एफिडेविट फाइल किया कि पेंडिंग?
हाँ तो पेंडिंग है, स्टिल पेंडिंग।
And my ladyship, just bringing to my ladyship's knowledge, in paragraph 20 we have said कि we are not taking any action for demolition of the structure.
आपका कंसेशन रिकॉर्ड कर दें।
It is on record.
Very good. आपकी तरह इस तरह से ऑर्डर नहीं होता,
नहीं, just
1 महीना का इंटरिम रिलीफ उनको देंगे, उसके बाद आपको जो मर्जी करें
as
और
my
डिसाइड
ladyship.
कर दीजिए। ठीक है, देखिए।
8 weeks.
Heard the learned counsel appearing on behalf of the parties. This petition has been filed for the following relief. The learned counsel for the petitioner has submitted that against the ensued order dated 18/6/2018 within bracket annexure 3, the petitioner has filed appeal being RMA case number 50 of 2018-19 before the court of Deputy Commissioner Dekar, and has stated in paragraph 17 that after issuing notice to 16 Anna Rayer of Moza Asana, the case was fixed for final hearing on 28/9/2018, and on 28/9/2018, after hearing the parties, the learned deputy commissioner pleased to kept reserve the order, and till the date of the filing of the petition, no order was passed. The learned counsel submits that under the aforesaid circumstances, the petitioner has filed the writ petition challenging the order dated 18/6/2018. A counter affidavit has been filed by the.
With humble apologies, reserve the order. There was no such.
Hold on, कुछ नहीं होता इससे।
Ladyship, reserve the order means the order was.
कोई बात नहीं, नहीं किए होंगे ना ऑर्डर, ट्रांसफर हो गया होगा, 2018 का सुनवाई तो फिर से करना पड़ेगा ना।
Order reserve नहीं था मेरे।
अच्छा कोई a counter affidavit has been filed on behalf of respondent number 225 dated 8/2/2019, wherein a statement has been made in response to the aforesaid paragraph of the writ petition in paragraph 17 of the counter affidavit, that after hearing the parties, the learned deputy commissioner fixed the case for orders, and order has not yet been passed by the deputy commissioner, and order was likely to be passed soon. The writ petition was filed before this court on 26/10/2018, and the aforesaid counter affidavit was filed, while affidavit dated 13/2/20 2019, sorry, 8 to 2019, meaning thereby that at least till that date also the order was not passed by the Deputy Commissioner. At this, counsel for the respondents has referred to another affidavit dated 26/9/2023, filed by respondent number 2, the Deputy Commissioner, wherein it has been mentioned in paragraph 4 that the appeal being RMA case number 50 of 2018-19 against the order passed by Subdivisional Officer Madhupur dated 18/6/2018 is on the stage of hearing. This court finds that the aforesaid facts reveal that the appeal was heard by the Deputy Commissioner at one point of time way back in the year 2018-19, and in the year 2023 also the appeal is said to be pending. The reason for not passing the final order by the then Deputy Commissioner is not on record. However, considering the fact that much time has elapsed and no final order has been passed in the appeal is certainly required to be heard afresh. Since the appeal has been filed against the impugned order and simultaneously the petitioner was compelled to move the petition because the appeal was, because there was no progress, no final order was passed in the appeal. This court is of the considered view that a date for hearing the appeal is required to be fixed by this court itself so that the appeal is finally decided. Since the impugned order is subject matter of appeal, there is no reason for this court to enter into the merits of the impugned order dated 18/6/2018. Consequently, this petition is disposed of, directing the petitioner as well as the private respondents and also the subdivisional officer. He will also appear?
He will also.
And also the subdivisional officer come LRDC Madhupur within bracket respondent number 4 to appear before the Deputy Commissioner on
Eight.
4th of December.
Not only one prayer. Why
Just a
appeal
moment,
has
please
not
hold
been
on.
decided?
Huh?
Why appeal is not being decided? Because he is not producing the register too.
कोई बात
The
नहीं।
Pradhani register, if
कोई
my
बात
direction
कोई-
he has to cooperate that.
अरे अब आप बीच में क्या बोलना है? आप रुकिए ना, आपका सारा चीज कर देंगे. 9th को appear हो जाएगा. On 9th of December 2024, since the appeal is pending since 2018, the Deputy Commissioner is directed to decide the appeal at 11 a.m. Appeal within a period of 1 month.
8 weeks में leadership कर दी. Just humbly praying because both the parties have to appear and
By 28th of February. ठीक है? By 28th of February 2025. 28 तारीख कौन सा दिन है? The parties to cooperate in the expeditious disposal of the appeal.
and
The Deputy Commissioner will call for the connected records and decide the case on merits.
a humble prayer for the quickly disposal of the cases
आपको
that
क्विकली डिस्पोजल में तो 1 महीना दे रहे हैं.
no parties should take unnecessary adjournments.
आप ही ना एडजमेंट मान रहे 2 महीना का.
हम तो
You are seeking adjournment.
हम तो मानते हैं leadership
हम तो 1 महीना से ज्यादा का टाइम दे रहे हैं.
दोनों प्राइवेट पार्टीज हैं, डॉक्यूमेंट्स आ रहा है नहीं आ रहा है.
आपको प्राइवेट पार्टी से क्या मतलब है? जो डॉक्यूमेंट ना प्रोड्यूस करे तो आप डिसाइड कर दीजिए.
मतलब हुजूर नहीं कर सकते बिकॉज प्रधानी मौजा का केस है, रजिस्टर इज विद द मुलट पिटिशनर.
लेके आएंगे आप.
He is not producing. Mullad,
You just file a petition for production.
Mullad, even 13 notices were given to the petitioner to produce. He has not done. For 13 notices were issued for Mullad, eviction. He is not done. So Mullad, the statement which is saying.
The parties are directed to cooperate for early disposal of the appeal by the Deputy Commissioner, and the appeal should be decided not later than 28th of February 2025. In case of non-cooperation by one or the other party, it will be open to the Deputy Commissioner to proceed in accordance with law.
That would suffice.
In the meantime, Lordship.
Just a moment. At this, the counsel for the petitioner submits that the petitioner that on the spot building has been constructed.
Lordship.
Building has been constructed. Some protection may be given. The petitioner has been enjoying interim order passed by this court.
Yes.
The petitioner has been enjoying interim order passed by this court. Considering the aforesaid circumstances, the interim order, no coercive steps be taken in connection with against one or the other party till 20th of December 2024, and it will be open to the parties to file 20 तारीख, and it will be open to the parties to file appropriate petition seeking interim relief.
28 फरवरी तक जो है तो 28 फरवरी तक
नहीं, डेप्यूटी कमिश्नर आप कोऑपरेट नहीं करेंगे तो वो आपको
नहीं, तो फिर नहीं करेंगे तो रहेगा। इफ आई विल नॉट कोऑपरेट देन डायरेक्शन ले दिया जाएगा,
ऑर्डर वहीं से कराएंगे।
तो फिर दिसंबर तक ही डायरेक्शन दिया जाएगा, दिसंबर में डिसाइड करते।
आपके अनुसार ऑर्डर नहीं होता है ना,
तो
केस डिस्पोजल करते समय इंटरिम ऑर्डर को कंटिन्यू करना, आप सुप्रीम कोर्ट का जजमेंट नहीं देख रहे हैं इसलिए आपको पता नहीं।
लेकिन जब तक जब तक वहाँ ये है तब तक के लिए
बस आपको 20 तारीख तक दे दिए ना, आप अपना आईए भी फाइल करिए एक्सटेंशन ऑफ इंटरिम।
ना तो फिर वो कहेंगे कि आपको मिला है नहीं तो फिर एक्सटेंशन क्यों करेंगे, तो इसलिए
नहीं मिला है, हम 20 तारीख तक दिए तो हैं।
हम फरवरी तक भी नहीं टाइम मांग रहे हैं, मुझे हमको अब जनवरी में डेट दे दिया जाए उसी दिन तक।
अभी इस ऑर्डर के अगेंस्ट में अपनी फाइल करिए, एपीए मेंटेनेबल है।
हम जनवरी तक में ही दिया जाए मुझे, एटलीस्ट जनवरी तक उसको दिया जाए ताकि कंटिन्यू करे, नहीं तो फिर उनके लिए
अपील पेंडिंग करके यहाँ पर रीट फाइल करना अच्छी बात तो नहीं, लेकिन आपका
हियरिंग करके
सर्कमस्टांसेस
ऑर्डर नहीं कर रहे हैं तो हम क्या करेंगे, मुसलमानों का तो काम है।
Sorry, I'm not couple of seconds.
कोई बात नहीं, एक आध और पास ओवर ऑर्डर्स मैटर से रुक जाइए।
But 18th of December.
18th
Yes.
वो जो पास ओवर था ना, counsel for the petitioner submits that an adjournment notice has been circulated yesterday. आपको खबर है? With the consent of the counsel for the parties, post this case on 18th December.
Item pass over case item 10 WPL 6351 of 2006.
Yes.
So here is the query. Stays granted regarding the payment. We have not got the instruction. कोई किसी तरह का payment लेकिन बनता नहीं।
नहीं आप हो
जी
किसकी तरफ से?
workman has died and in his
Which workman has died?
in this case
Which workman? There are two persons.
there was only one workman who died and in his place his two sons were substituted and I have filed wakalatnama on behalf of only one.
So why the other one you have not filed?
He has not contacted neither my the person who had given me the wakalatnama has not stated anything regarding his brother.
So is he avoiding notice? Because you were living in the same place.
No,
You have his address, you have his present and correct address, your own full brother.
He is residing at the same locality, my lord, but
You give us the complete address of your brother, full brother. Or you say that you don't have any idea. कहाँ से खोजेंगे, कितना बार नोटिस करेंगे?
the notice.
पेपर पब्लिकेशन क्यों कराएंगे हम लोग? Full brother is appearing before this court.
Yes.
You can't deny knowledge of his address.
So, service of notice is valid.
नहीं है valid. Valid नहीं है ना?
Then I will supply.
Are you supply? कल बताइए, हो जाएगा? फोन नंबर है आपके पास उनका?
उनका इन लोग का तो नहीं है, लेकिन
अब ये वेस्ट बंगाल का एड्रेस है, बंगाली में आता है लिखा हुआ सर्विस रिपोर्ट। हमारा ऑफिस बोलता है हमारे पास ट्रांसलेटर नहीं है, तो क्या ही हम लोग करेंगे? You are the full brother, you supply his address.
एक सप्ताह
एक हफ्ता कोई बात नहीं, take your time. ठीक. WPL number 6351 of 2006. Counsel for the parties are present. Mr. B.V. Kumar submits that he has filed wakalatnama on behalf of one of the sons of deceased workman. The name of the son is Ainul Haq Ansari. So far as the other brother, so far as his full brother is concerned, he submits that he has not received any instructions. However, he undertakes to furnish complete address of his full brother along with PIN code number. He submits that the matter be posted in the next day. Post this case on Tuesday in the supplementary correspondence for office. The publication is an expensive affair, no? What is the big idea?
He is not appearing, he is being full brother, and he will also be a beneficiary.
पता नहीं ना जीवित है नहीं है क्या है आप ही बताइए. और अगर मान लीजिए वो जीवित नहीं है तो उनके लीगली उसका नाम बताइए. पैसा तो आपको नहीं मिला होगा अभी तक आई सपोज, तो फिर इसका पेंडेंसी से आपको क्या ही फायदा.
Extra burden upon me personally.
अब इस बर्डन को दूर करते हैं, कोर्ट का भी और आपका भी.
Pass over case from supplementary list item 3 WPC 3662 of 2020.
Yes, where is the petitioner? Where is the petitioner? Mrs. Ritu Kumar was to appear in this case. आपका मैटर नहीं है सर, ये दूसरा मैटर. Mrs. Ritu Kumar has not come to the court today. I have seen her, I think.
Perhaps GB is going on. I am
Kal
not
ke
aware
liye.
whether it has been continued.
Kal ke we'll give her an opportunity. We'll post it, and we'll post it every day.
Edition.
Nobody appears on behalf of the petitioner. In spite of repeated calls, post this case tomorrow. You have gone through the report.
Edition.
Pass over case from supplementary list item 4 WPC 2336 of 2021 along with item 5.
Correct. May please, Your Lord. Lord, in this case, the petitioner has prayed that the circle officer has passed an order on Extra 5 that it will await for the disposal of the writ petition filed 3 years earlier in 2021, and that has longed for till date only because the CO doesn't want to proceed in the matter.
Which record should I take up?
But my case is item 3 and the
2336.
2336, item number 4, my lord.
This is 2336 is your case.
It is my case.
Let us see what is the cause of action to come.
And the corrected case was filed earlier to it is serial number 5. That is in fact the earlier case.
Which case do you want to press first?
But I will press my case.
So so far as other cases concerned, nobody is appearing, so I'll dismiss that. I'll dismiss it. If you are not,
Just now my friend was here.
I do not know. There is nobody to even pray for time. We will dismiss it. कल से आज आया है ना, ये तो नहीं है कि कोई नया ही ऑर्डर है अचानक.
वो आज तो मेरे लिए आया है. I had gone to attend a marriage at Junction.
That's no problem. म्यूजिकल चेयर तो नहीं चल सकता ना कि आज एक आदमी आएंगे कल दूसरे आदमी आएंगे, ऐसा तो नहीं चलेगा.
Respondent of 5, 6 and 7 are appearing through a learning council. They have also filed a writ petition, connected case, WPC number 429 of 2021, much earlier to my case, and it was adjourned on payment of cost twice, 1,000, second time 5,000. And for that, the CEO is saying that although there is no interim order, I will await for the disposal of that case.
Let us see your relief.
My lord, my prayer is that demarcation of land we wanted, because the private respondent has encroached upon my land, and he has constructed 2 shop rooms.
Now
then-
there is a suit pending.
Miller suit has been filed later on in 2023, and
You see,
I have
in a
received
case-
a notice. I have appeared also.
Very good.
But Miller, for
Now,
every
no,
small
just,
thing,
Just a moment. In a case where suit is pending,
my lord,
right, there is no question of passing any order on the point of demarcation.
my lord will kindly consider.
Because that will create unnecessarily trouble in the suit.
My lord,
So
they have not
if
prayed
I'll-
for injunction.
No, they need not pray for injunction. The point is, Mr. Sai, please appreciate this. When a suit is pending between the same parties in connection with the same property,
My lord,
is it proper for this court to pass an order that it should be demarcated, it should be measured, the circle officer should do this, that? This is not proper. We will not do this. We will restrain ourselves from doing it. There were certain steps which were taken by the circle officer for the purposes of demarcation.
my lord,
At that point of time, for one reason or the other, the demarcation could not take place.
my lord.
But as of now, the suit has already been. Whatever relief both of you want, you go to the civil court. This was my only concern, so that is why I kept it today. So it will not be proper to create some evidence by sending the circle officer, and then this is not proper.
Then let him pass an order, my lord, need not pass any order, let him pass any order.
Who ordered?
Let him decide the petition I have filed. Let him decide. Let him decide.
We will not say anything more.
My lord. And my friend is appearing in the next case.
In the next case, both parties are saying both the
Yes.
cases, and I supplemented affidavit. It
No,
is
he has said, he has fairly said that he has received the notice in the suit.
I have appeared also.
and it is my land. I have obtained the
Everybody is saying, and I
compensation.
am also saying.
Entitled everything.
You have appeared in the title suit?
My lord, my lord. In this writ petition also I have appeared, the earlier writ petition, WPC 429 of 2021.
WPC number 429 of 2021 with WPC number 2666 of 2021. Learned counsel for the parties are present. These writ petitions have been filed for the following. The learned counsel for the petitioner in WPC number 2336 of 2020, learned civil counsel, has submitted that an application for demarcation was filed, but
For measurement, not demarcation, my lord.
okay, for measurement was filed,
Okay.
but the circle officer did not proceed in the matter.
My lord.
And when certain order was passed, the
And it's a 5 minute, page 22.
when certain order was passed, the same was challenged in the writ petition being WPC number 429 of 2021.
नहीं वो हम फाइल किए थे इन लोगों ने
429 कौन फाइल किया?
हमने फाइल
इनने
A writ petition being WPC number 429 of 2021 was filed by the private party, by the persons who are private party in WPC number 2336 of 2021. Consequently, the petition seeking measurement etc. has not been taken to a logical end by the circle office. The learned counsel appearing on behalf of the private respondent in WPC number 2336 of 2021, who are the petitioners in WPC number 429 of 2021, has submitted that the petitioner of WPC 2336 of 2021 are trying to disturb the peaceful possession of the petitioner in WPC number 429 of 2021. He has submitted that now a title suit in connection with the same property has been filed and the matter is sub judice before the court, in which notices have already been issued. The learned counsel submits that under such circumstances, no mandamus be issued in this court, by this court, as the same may have a direct or indirect bearing in the pending suit. Counsel for the petitioners in WPC number 2336 of 2021 has submitted that notices has already been served upon the petitioners in the suit, who are the dependents, and so far as the petition filed before the circle officer is concerned, it may be kept open to the circle officer to pass appropriate order on the petition.
This is not.
After hearing the learned counsel for the parties and considering the fact that a title suit has already been filed and is pending, this court is not inclined to pass any direction as prayed for by the as prayed for in the aforesaid two petitions. Accordingly, this petition are hereby disposed.
But CO may be.
CO, my lord, CO, we have filed the counter evidence, my lord. CO, he has issued notice after getting application, online application. He issued notice to both of the parties for measurement, my lord. And
Yes.
the date was fixed on 27th of 11/2020, my lord. And thereafter,
We will not pass any mandamus. Why should we pass any mandamus?
No, it may be kept open for the CO to take any
कुछ
decision.
भी हमको बोलने का जरूरत
Otherwise, this will hinder.
rather जब
Without
suit pending
obtaining
हो
a stay
ना,
order, he has prolonged the matter for 3 years.
we will not pass any direction.
report of comment is also there.
आपको जो करना है करिए. पेंडिंग सूट में
हाँ,
तो
बस
सीओ
उतना ही
को
उतना ही हम चाहते हैं कि वो
आपका
जो करे।
सबमिशन रिकॉर्ड कर दिए हैं, मैंडेमस हमने इशू करेंगे. बस
नहीं,
इतना.
mandamus नहीं. Ballot may leave it open to the authorities.
It is open to the parties to proceed in accordance with it.
बस,
हो गया?
ballot.
चलिए.
अब नहीं.
पेंडिंग सूट में सीओ को नापी करने का क्या ही काम है? कोई काम है?
मिनट अगर छोटे-छोटे केस में सूट फाइल करके हम लोग
नहीं, हम ऐसा नहीं बोल रहे हैं कि नापी कराने के लिए सूट फाइल करना होगा, लेकिन पेंडिंग सूट में नापी कराने का कोई काम नहीं. हम ये बोल रहे हैं.
अब तो ये सूट 3 साल के बाद फाइल.
सूट तो कभी भी फाइल हो सकता है. आदमी ना रहे, जमीन तो रहेगी.
मैटर
बहुत
टाइटल
होता है.
टाइटल भाई
इंट्रीम ऑर्डर स्टैंड वेकेटेड.
इंट्रीम ऑर्डर है.
कहाँ मैं क्या हो गया पहले
इस टीम
If any.
अब ले.
हाँ, continue.
Continue test item 1 WPL 2947.
सर आपका भी कोई मैटर है फर्स्ट हाफ में टेकअप हुआ था मिस्टर मंजू? सेकेंड हाफ के लिए है. अच्छा रुक जाइए, एक मैटर आधा सुना हुआ.
इसमें ज़्यादा देर लगेगा
हाँ?
इसमें ज़्यादा देर नहीं लगेगा
ज़्यादा देर नहीं लगेगा,
मुझे तो पर्च
तुरंत ही हो जाएगा.
ये मेरा
हम आपका सब सबमिशन
आधा साइड बैठे हुए थे साथी थे हम लोग वही ठीक हो रहे हो म्यूजिकल चेयर बना,
म्यूजिकल
कभी हम रहेंगे कभी वो रहेंगे.
आ गया मिस्टर
मेरा इतना ही सबमिशन है कि all the three issues have been decided by the final. So no other issue is to be decided if it is remitted back again. Number one, your lordship may kindly consider three aspects of the matter. First of all, admittedly, the demand was raised in 1989, and these litigations are pending since 1989. We are in 2024. He already retired. He already attained the age of superannuation while in service. Number second aspect of the matter would be that the honorable, the first round litigation, they preferred writ petition to permit them to direct the labor court to decide the preliminary objection. That was decided in their favor. They were asked to appear and file their objection. Then thereafter the matter, they proceeded, they participated in the proceeding, and they laid evidence. 2 witnesses were examined. 4 exhibits were marked on their side. 4 witnesses have been examined by the workmen, and 10 exhibits were marked. After consideration everything, in between, they challenged the award was passed against the workmen. And that award was before this honorable court at their instance, at the instance of the management. And the award was without at the instance of the workmen. They succeeded, therefore we approached this court, this honorable court. I was the lawyer appearing on behalf of the workmen, and the matter was not decided on merit against the final award, not preliminary award. Then that was affirmed up to the Honorable Supreme Court. Both the courts, the Honorable Single Bench, while referring the matter again to decide the matter, remitted the matter again, directed the Labour Court to decide on the materials available on record and time frame, 6 months. That order was passed in 2010. Then they preferred an appeal. The LPA was also dismissed. It was also, the division bench also affirmed the order of the Honorable Single Bench. Then they went to Honorable Supreme Court. And the Honorable Supreme Court did not interfere with both the orders. However, the Honorable Supreme Court says any observation, they are at liberty to raise all points before the Labour Court. The Lordship may kindly see Annexure 13, page 151. It shall be open to the petitioner, the management, to raise all the contentions as may be available to it in accordance with law before the Labour Court. The Labour Court, while deciding the matter, shall not be influenced. So this is the observation. Now, my lord, on the thereafter they filed a petition, a single page handwritten petition, without any contents thereof, save and except with a prayer that they may be allowed to file an additional written statement. Nothing about preliminary objection or anything, as page 152. And that was rightly rejected with reason order. After quoting the order passed by the Honorable Single Judge, after quoting the order passed by the Honorable Supreme Court, the learned Labour Court rejected that petition. Then thereafter, in 2011, they preferred the first writ petition. There was no stay order. They made a prayer for stay, but the proceeding was not stayed, and therefore they participated in the proceeding. And it was contested. They filed their written submissions, and ultimately Annexure 17, page 161 is the final one, which is in the second writ petition. So there are 2 writ petitions, one at the initial stage in 2011, another in 2012. When the award was challenged by them, by Lordship may kindly see for a moment page 161, especially paragraph 5, page 164. In the second writ petition, 164, paragraph 5. 3 issues were framed. Number 1, with regard to maintainability of reparations. Number 2, whether the workmen of Disco Tubes Recreation Club are entitled to get pay and other benefits. And number 3, whether the workmen of Disco Tube Division for Recreation Club should be treated as the workmen of Disco Tube Division. if the language of both all the three issues are read, my lord, your lordship will find each are interlinked with each other. Number this, therefore, the learned labour court, after recording para 6 and 7, what has been laid by way of evidence, discuss the evidence of both parties. Para 6, 7 in extenso. Then, my lord, para 8 is item issue number 1 with regard to maintainability of reference, the preliminary issue which they have raised or wanted to raise. Now, your lordship may kindly see para 8 runs in so many pages. After considering all the documents as well as the judgments cited by them, law points, and thereafter also the exhibits, everything has been discussed in at length in so many pages. And ultimate finding, paragraph 10. Paragraph 10, Lord, the findings have been recorded. If you also may kindly see page number 171. Having regard to the above facts and circumstances of this case, submission of the parties, written notes, I am of the view that the concerned workmen have raised their dispute before TISCO management, and Government of Bihar has formulated as the terms of reference as per the demand of the workmen, and it has the jurisdiction to adjudicate. This court has the jurisdiction to adjudicate the dispute of the present reference, thus it is maintainable. Thereafter, issue number 2 and 3. Now, what the learned labour court has referred below, and the case of the management is such and such. Workmen were employed by Indian Tube Company for the recreation club, and they are being paid by club from the collection fund of the membership of the club members, and management has no any concern with their service matter. Hence, the workmen not to be treated as workmen of TISCO in Tube division, and they are not entitled to get any wages. But as stated above, I have found that after merger of Indian Tube Company in the year 1986, it has become Tube division of TISCO, and activities of erstwhile company has been made as one of the division of TISCO Limited. And since then, the employees of Tube Company became the employees of TISCO Limited under its welfare department, and the recreation club is organizing the sports and cultural program for the workmen and their wards of TISCO Limited. They are working in recreation club from 1983-85. The recreation club is totally governed and controlled by TISCO management through its finance officer by constituting the managing committee. And thus, the employees of the recreation club are also the employees of TISCO Tube division. They must be treated as the workmen only. So, which question was left to be decided? But these findings are based upon oral and documentary evidence laid by both the parties, tested by this honorable court also, tested by the honorable division bench, and then thereafter the honorable Supreme Court did not interfere with the previous judgment.
You just now read para number?
Para number 10 and 11.
Of the?
11 and 12 of the final award, that is at page 171 and 172. Before that, the discussion in the preceding paragraphs. And the order impugning the first writ petition is well reasoned order, and it was not, it is not the leisurely and pleasurely a handwritten petition was filed at page 113 of the first writ petition. And the petition only contention that they may be permitted to file a additional written statement. Nothing more. And thereafter, when it was rejected, they approached the Supreme Court. There was no stay order. They participated in the proceeding. Can they raise the same point at the again and again? Is it not be a constructive res judicata? Within 6 months on the same materials. These were the observation affirmed up to the Honorable Supreme Court. They want to prolong the matter, prolong the litigation. By now he retired, now he may die. This is the situation. For last 41 years he is fighting. Poultry sum of rupees 7,50,000 has already been paid to the other workmen by way of compromise. Every point they have raised, that is, would be evident from award, evident from their written notes of argument. every point, maintainability, no relationship, and it is dealt by the labor code in extenso. This is third round. Therefore, my humble submission, not taking into consideration all these aspects of the matter, she may decide it in the interest of justice, whichever may be suitable.
Heard the learned counsel appearing on behalf of the parties. Both the writ petitions arise out of the same reference case, being reference case number 22 of 2019, 22 of 1991. WPL number 2947 of 2021 was filed challenging the order dated 1/3/2011, passed in the aforesaid reference case, whereby the learned Labour Court Jamshedpur rejected the petition filed by the petitioner dated 19/1/2011 a petition was filed by the petitioner the said petition dated 19/1/2011 was filed by the petitioner praying for time to file additional written statement raising all legal issues as available to the petitioner. The same was rejected by the order dated 1/3/2011 and the matter was directed to be posted for final hearing on 21/3/2011. The petition was filed before this court on 9/6/2011, and in the meantime, the Labour Court proceeded in the matter and passed the final award dated
25th October 2011.
25/10/2011, which has been impugned in the connected writ petition being WPL number 794 of 2012. The counsel appearing on behalf of the petitioner has submitted that The case has a checkered history. While referring to the records of WPL number 2947 of 2011, it has been submitted that a demand was raised by 4 persons claiming themselves white letter dated 1/8/1989, claiming themselves to be the employees of Recreation Club Disco Tubes Division, Baridi, Jamshedpur. And thereafter, notices were issued to the concerned club, and upon failure of conciliation, the matter was referred for adjudication by the Labour Court Jamshedpur. The terms of reference are as follows. Page 40 में है, ठीक है? Quotation. Whether the workmen of Disco Tubes Recreation Club, Baridi, Jamshedpur are entitled to get pay scale and other benefits admissible to the workmen of Disco Welfare Department, Community Development Center, Hospital, Health Department and Electricity Department. Question mark. If affirmative, then what pay they are entitled to and from what. Number 2. Whether the workmen of Disco Tube Division Recreation Club Baridi Jamshedpur should be treated as workmen of Disco Tube Division or not. The learned counsel submits that since Disco was never noticed at the stage of conciliation and no demand was raised against Disco, as essentially the demand was in connection with the recreation club, the reference itself, the petitioner upon receipt of notice from the Labour Court appeared before the Labour Court and raised a preliminary objection saying that the reference against the petitioner was itself not meeting. वो तो बाद में फाइल किए ना, I think. You straight away challenge the terms of reference.
Well, in the terms of reference, it is between Tisco and the management.
Right.
And except to civil लिखा हुआ.
They, the petitioner, ये मत लिखिएगा है ना? They filed a written statement. You filed a written statement also.
We filed written statement. That is
Just I'm just
Your
getting
Lordship
back.
will
Annexure
refer to
4. Annexure.
Yes. First
Within bracket Annexure 4, raising a point that the तो बाद में फाइल के 92 में Annexure 4
11/9/91. That is my
नहीं, the ऐसे लिखिए, after receipt of notice from the Labour Court, the petitioner filed a petition being CWJC number 2357 of 1991 within bracket R and raised the question. You filed a written statement in 1992.
Yes, after the order of this.
Yes. and raised a point as to whether the industrial dispute existed and challenged the reference itself by saying that it was not maintainable. The said writ petition was decided by the order dated 19/11/1991 and by observing that the contention raised by in the writ application can be raised before the respondent number 1, who may decide the jurisdictional points raised by the petitioner, and the writ petition was not entertained at that stage. Thereafter, the petitioner filed their written submission, written statement before the Labour Court Jamshedpur in the reference case, and stated that the jurisdictional issue may be decided and taken up as a preliminary issue, and the award be pronounced on the basis of the decision on that issue, holding that no industrial dispute existed for adjudication and the reference was incompetent. The written statement was also filed by the concerned workmen, and evidences were led before the Labour Court by both the parties, and an award dated 8th of October 1999 was passed. We have submitted that in the reference case, 3 issues were framed, including the point of maintainability of the reference as point number 1, and the point of maintainability was decided in favor of the writ petitioner, and ultimately the court, having held that the reference was not maintainable, the other 2 points, the court did not make any comment or deal with the evidence, either oral or documentary, adduced on behalf of the parties in connection with point number 2 and 3. And thus the award was passed only with respect to, and the detailed order was passed only with respect to point number 1. The said award deciding the preliminary issue in favor of the writ petitioner management was challenged by the concerned workmen in CWJC number 1802 of 2000 which was decided on 30/7/2008, and the Learned Council has specifically referred to the findings recorded in the writ proceedings and has submitted that the order was passed deciding the entire merits of the case and not merely on preliminary issue decided by the Labour Court, and the matter was remitted back to the Labour Court to decide the reference on merits on the basis of records already available, preferably within a period of 6 months. We submit that the order passed by the writ court was challenged in LPA number 359 of 2008. The appeal was also dismissed by order dated 29/1/2010. Against the same, the writ petitioner management went to the Honorable Supreme Court in special leave appeal in that is civil number 14117 of 2010. And he submits that the order of the single judge remitting the matter to the Labour Court was not disturbed by the Honorable Supreme Court, but it was observed that the Labour Court, by deciding the matter, shall not be influenced by any observation made by the learned single judge and division bench of the High Court in the orders impugned before the Honorable Supreme Court. The learned counsel submits that since the petitioner had filed the written statement only on the preliminary issue on the point of jurisdiction, on which a specific issue was also framed by the court as to whether the reference was maintainable. Upon remand after the judgment passed by the Honorable Supreme Court, they filed a petition praying for time to file additional written statement. The petition was dated 19/1/2011. He submits that the said petition was rejected by the order dated 1/3/2011. By observing that, as per the order passed by the learned single judge, the case was to be decided on the basis of materials available on record. And there was no available on record, and the learned counsel submits that the learned Labour Court has misread and misunderstood the judgment passed by the Honorable Supreme Court, wherein it was clearly mentioned that the Labour Court would proceed without being influenced by any observations made by the Labour Court will decide the matter without being influenced by any observation made by the learned single judge and the division bench of the High Court in the orders. The learned counsel submits that consequently the final award was passed, whereby only the written statement of the management on the point of jurisdiction was on record, and the management was deprived of filing the written statement on the merits of the case by the order impugned in by the order dated 1/3/2011. He submits that the management has been ultimately deprived of contesting the case on merits. Okay?
Yes.
He has also submitted that if the order dated 1/3/2011 is found to be perverse, then the natural consequence would be the final award is also to be set aside, and an opportunity is required to be given to the petitioner to file the additional written statement, and then the matter has to proceed in accordance with it. Okay?
Yes, ma'am. We'll need more evidence, etc.
That's it. The learned counsel, appearing on behalf of the respondents while opposing the prayer, has submitted that the order which was passed earlier, dated 8th of October 1999, wherein the preliminary issue was decided, revealed that the parties had led the respective evidences on the merits of the case as well. And the earlier court had simply decided the case on the preliminary issue and not decided the point number 2 and 3 as framed. Therefore, the matter was remanded by the writ court in CWJC number 1802 of 2000 within bracket R, with a specific observation that the case has to be decided on the basis of materials already available on record. he submits that on the face of such observation, there was no occasion to lead to file additional written statement or to lead any further evidence by both the parties. The case was to be decided within a short time of 6 months based on the materials already available on record. The Learned Counsel further submits that the order of the writ court was upheld by the division bench and the appeal was dismissed, and ultimately the SLP was also dismissed without interfering with the order of the learned single judge remitting the matter to the Labour Court. He submits that since this order remitting the matter to Labour Court was not disturbed by the Honorable Supreme Court, therefore there was no occasion to lead any further evidence, and the case was to be essentially decided on the basis of materials available on record. The Learned Counsel has also submitted that the petitioner has a tendency to linger the matter, and they had only filed an application for filing additional written statement on merit, which was just a handwritten application, and the same was rejected by the order dated 1/3/2011 by citing reasons. The said order is a well-reasoned order which does not call for any interference under Article 226 of the Constitution of India. It does not suffer from any perversity. However, during the course of hearing, it is not in dispute that if the order dated 1/3/2011 is disturbed by this court, the same will have a direct bearing on the final award. The Learned Counsel at this stage has also submitted that the concerned workmen have already attained the age of superannuation
On 1/1/2019.
on 1/1/2019. सबका अलग अलग होगा. Let's not अभी
Concerns, yes.
After hearing the Learned Counsel appearing on behalf of the parties, and upon going through the checkered history of the case as narrated by the Learned Counsel appearing on behalf of the petitioner, this court finds that the concerned workmen claimed to have been working in the recreation club of Tube Division, Jamshedpur, and it is further not in dispute that the erstwhile Indian Tube Company was taken over by Tata Steel Limited in the year 1986, and the dispute was raised in the year 1989. It further appears that 1889. It further appears that the dispute was referred for adjudication. The terms of reference has already been quoted above. The petitioner having received notice from the court, filed writ petition being CWJC number 2357 of 1991, questioning the terms of reference itself. And this court was of the view that the preliminary issue with respect to the jurisdiction be decided by the Labour Court itself, and consequently the operative part of the order passed in CWDC number 2357 of 1991 is quoted as under. Page 57 का last वाला portion थोड़ा quote करना. हाँ. ठीक है? It further appears that on account of the preliminary jurisdictional issue, the petitioner filed its written statement clearly stating that raising the jurisdictional point and stating that the same be decided that as the preliminary issue. It further appears that thereafter the parties led evidence and the award dated 8th of October 1999 was passed, and on account of the jurisdictional point raised by the petitioner, the following three issues were framed, which included as to whether the reference itself was maintainable or not. The learned court decided the point number 1 and recorded its finding in paragraph 22 as under. Page 88 when you will get the finding. The finding in para 22 with regard to point number 1 revealed that the reference was held to be bad, incompetent and not maintainable. Consequently, the learned labour court did not proceed to decide the point number 2 and 3 as framed and observed in paragraph 23 as under. Para 23 before that. The said order was challenged by the by the concerned workmen in CWJC number 1802 of 2000 within that is R, and this court passed a detailed order touching upon the merits of the claim of the rival parties by order dated 30/7/2008 and ultimately by paragraph 17 remitted the matter to the labour court to decide the reference on merits on the basis of records already available, and a time frame of 6 months was also granted. Para 17 quote कर देंगे. Internal page 7 में. Running page would be 107. The LPA was also preferred against the order passed by the learned court, which was dismissed by the order dated 29/1/2010. However, by dismissing the appeal, by dismissing the LPA, the Honorable Division Bench recorded in paragraph 7 that observed in paragraph 7 that the appellant within bracket the present petitioner bracket close may take all points that may be available under law before the labour judge, who will decide the reference after giving full opportunity of hearing to both the parties. Paragraph 7 of the order passed in LPA number 359 of 2008 is quoted as under. The matter went up till the Supreme Court. The Honorable Supreme Court passed the following order. Page 112 में quote करेंगे. The order passed by the Honorable Supreme Court clearly reveals that the order remitting the matter to the learned labour court was not put in bed. But at the same time, the Honorable Supreme Court clearly observed that the labour court, by deciding the matter, shall not be influenced by any observations made by the single judge and division bench of the High Court in the orders impugned, and it was to be decided, and all contentions as may be available will be decided in accordance with law. This court finds that after the order passed by the Honorable Supreme Court, the petitioner filed a petition seeking time to file additional written statement. This was apparently because of the reason that the initial written statement was filed only on the point of preliminary issue, wherein the petitioner had questioned the reference itself. The same was filed pursuant to the earlier order passed by this court, wherein it was clearly observed that the preliminary issue on the point of jurisdiction will also be decided by the concerned labour court. This court finds that by rejecting the said petition seeking to file additional written statement, the learned labour court passed the order dated 1/3/2011 by observing that the single judge had directed to decide the reference on the basis of records already available on record, on the basis of records already available within 6 months. And therefore, apparently, the learned labour court was of the view that whatever evidence or material has been placed on record before the labour court, nothing further was required to be placed on record. This court finds that the order dated 1/3/2011 passed by the learned labour court is perverse inasmuch as the learned labour court has failed to take into consideration that the order passed by the Honorable Supreme Court clearly revealed that the Honorable Supreme Court did not interfere with the order of remand passed by the learned writ court, but the matter on remand was to be decided in accordance with law and without being influenced by any observations made by the learned writ court and also the LPA court. This court also finds that even the LPA court, while dismissing the appeal, had observed that the appellants, that it was open to the appellant, the petitioner, to take all points that may be available under law before the labour judge, who was to decide the reference after giving full opportunity of hearing both the parties. The learned labour court has misunderstood and misread, has apparently the learned labour court, while passing order dated 1/3/2011, has failed to consider that the matter was to be decided without being influenced by any observation made by the learned single judge. And one of the observation was that the case was to be decided on the basis of materials already available on record. Having said so, the impugned order dated 1/3/2011 being perverse calls for interference. This court is also of the view that on account of the impugned order dated 1/3/2011, the management has been deprived from contesting the case on merits, and what remained in the record from the side of the management was only their point raised on preliminary, on jurisdictional issue. Since the order dated 1/3/2011 has been found to be perverse, the same is hereby set aside. Consequently, the subsequent award which has been passed during the pendency of the writ petition, being the WPL number 2947 of 2011, and the final award under challenge in WPL number 794 of 2012, which is a sequel to the impugned order passed, impugned order dated 1/3/2011, also cannot be sustained in the eyes of law, as the final award has been ultimately passed without granting opportunity to the writ petitioner to file their written statement on merits. This court is further, in such circumstances, although this court is conscious of the fact that the reference itself is an old reference, but at the same time, the prejudice, at the same time, the manner in which the learned labour court has proceeded in the matter after the order of the Honourable Supreme Court cannot be sustained. In view of the aforesaid, the final award dated 25th of October 2011 is hereby set aside and the matter is remitted to the Learned Labour Court for fresh consideration. The petitioner to appear before the Learned Labour Court along with their additional written statement by what date?
So within what's within 2 months notes?
2 months will be too long a time. No, fine.
Numbers?
With the additional written statement.
Ah, yes, sir. That is.
Within a period of 1 month. The parties to appear before the Learned Labour Court on एक डेट दे देंगे ये बात since the award since the reference is very old, the Learned Labour Court is directed to proceed and expeditiously decide the matter within a period of 6 months from the date of appearance of the parties and shall not grant unnecessary interference. इसका रिकॉर्ड भी आया है। हम डेट देंगे सर, आपका ऑर्डर में रहेगा। हम जिस दिन ऑर्डर अपलोड होगा ना उससे टेंटेटिव 1 महीना का हम देंगे, ठीक है ना? थोड़ा सा टाइम लगेगा अपलोड होने में, इतना हिस्ट्री कहानी तो ज़्यादा ही हो गया।
कभी कभी इसीलिए हुजूर हम लोग इंसिस्ट करते हैं ऑब्जर्वेशन। कोई रीट जब डिसमिस होता है हम लोग ऑब्जर्वेशन का इंसिस्ट इसी कारण से कि उसी का फायदा हो जाता। हम अप्रिशिएट करते हैं कि जरूरी था, उसी समय डिसाइड हो जाता। 11 में हुजूर अगर हो जाता या स्टे दे देते इनका फर्स्ट रीट में, आज ये दिक्कत नहीं होता, आज ये दिक्कत ही नहीं होती। सर कोई बात नहीं।
From Delhi list item 4 WPC 6668 of 2015 along with item 5 and 6.
Your mediation in this state was directed to produce the original records.
Where is it?
Only of 2 SAR case we have received the original records.
बाकी का क्या होगा?
बाकी वो अभी खोज रहे रिकॉर्ड में एक वीक के लिए
हम टाइम देंगे, पुराना रिकॉर्ड है खोज के निकालें, इसीलिए तो हम लोग टाइम देते हैं रिकॉर्ड निकालने के लिए। ऐसे डिस्पोजल कर देंगे तो क्या ही होने वाला, गुम नहीं ना कर दिए हैं।
नहीं,
कौन कौन सा रिकॉर्ड आपको मिल गया है?
ये SAR 15 of 85-86
SAR 15 of 85-86
and 14 of 85-86
14 of 85-86। बाकी 2 रिकॉर्ड और है।
तीन होंगे, एक SAR अपील और रिवीजन।
अच्छा, अपील और रिवीजन वो तो इतना ज़्यादा रेलेवेंट नहीं होता है, लेकिन फिर भी आप खोज इसको भी देखना ज़रूरी है। रिकॉर्ड देख के ऑर्डर किए हैं कि ऐसा ही ऑर्डर करते हैं? बहुत सा केसेस में हमको लगता है रिकॉर्ड कॉल फॉर भी नहीं करते हैं।
आपकी नहीं होता।
उसके बाद यहाँ पे होता है कोई परवर्सिटी नहीं है, 3 कोर्ट से हार गए हैं, बस यही कहानी है। ठीक है, आप उसको टेस्ट कर लीजिए तो हो जाएगा।
इसको रिकॉर्ड
नहीं, ऐसे हम तो नहीं रखेंगे। पहला बात, इसका फोटोकॉपी करा के एक कॉपी हम लोग को,
एक कॉपी हम लोग भी दे देते हैं।
आपको किससे देंगे?
हम लोग भी थोड़ा देख लेते हैं।
आपको क्या ही मतलब है?
हम लोग भी देख लेते हैं।
नहीं, ये सब हम आपको इस तरह से नहीं दे सकते। नहीं, इतना ही था तो खुद ही अपना सर्टिफाइड कॉपी निकालते हैं ना सारा। डेट ऑफ डिस्पोजिशन क्या है?
डेट नहीं,
जमीन का 1960 नहीं 1970।
नहीं, इनका कहना है कि 46 में परचेज किए हैं।
भाई हम तो एप्लीकेशन देखते हैं ना, पहला डॉक्यूमेंट ही वही खोल के देखते हैं। डेट ऑफ डिस्पोजिशन दिख रहा है जनवरी 1970, देखिए जरा। मिला? ये 15 वाला रिकॉर्ड। और ये 14 में है 7-8 साल से। ₹50,000 का कंस्ट्रक्शन है, ठीक? इसमें क्या है? मकान बना हुआ है। डेट ऑफ डिस्पोजिशन मिला है सर, उसका देखिएगा क्या कॉन्सिक्वेंस है। डेट ऑफ डिस्पोजिशन as per the application filed under section 71. The date of disposition as per the application, in one case it is 7 to 8 years and in the other case it is 1970.
ये तो
हिंदी में लिखा है।
हिंदी में लिखा। जमीन के हस्तांतरण की तिथि
जनवरी 1970।
ये तो सेकंड राउंड
केस फाइल किए 85-86 में।
वो हम नहीं जानते।
It is second
है,
or
लेकिन इसका बहुत रेलेवेंस है। This date has a lot of relevance.
It is second or third round of rating.
अब आखिरी राउंड है। अब आखिरी राउंड, इसीलिए रिकॉर्ड मंगा दिया। चलिए, learned counsel for the parties are present. Counsel for the state has submitted that the records of SAR case number 15 of 85-86 and 14 of 85-86 have been received by him, original records. He has submitted a photocopy of the same before this court, and he submits that he shall retain the original for perusal of his court as it may required, and keep the records in the safe custody. So far as the appellate and revisional court record are concerned,
SAR appellate and
SAR appellate and revisional court record, in connection with both the cases, are concerned, he has yet to receive the same, and accordingly he seeks adjournment. कितना टाइम आपको चाहिए? 2 हफ्ता में हो जाएगा?
हाँ। A particular date we can give it, and the time is 2:15.
तो कौन सा ऐसा केस है इस कोर्ट में जिसमें डेट फिक्स नहीं होता?
नहीं, डेट फिक्स रहता है लेकिन 2:15 का ब्रेक है।
आपको 2:15 सीनियर एडवोकेट्स को 2:15 का राइट। ठीक, पोस्ट दिस केस ऑन 11 दिसंबर को रखें, 18 को रखते हैं। 16 तारीख 16th of December 2024। ठीक,
at 2:50
at 2:50 इसको ठीक से रख दीजिए।
Fixed case from supplementary list item 1 WPL 2796 of 2001.
आप अपने जजमेंट्स प्लीज करें। यस ऑफ कोर्स, इतना मोटा मोटा जजमेंट हम अकेले बैठ के कितना ही पढ़ेंगे। कल जजमेंट्स हम लोग के पास था ही कहाँ? पहला जजमेंट शुरू करें।
पहला हम लोग दीनानाथ देख लेते हैं।
दीनानाथ
92 SCC।
हाँ, यस, सब है मेरे पास। What was the issue?
Issue was the tribunal has held that since the establishment was not registered and the contractor did not have license, therefore the contract itself is a camouflage.
पैरा 2 पढ़िए इतना क्लियरली.
हाँ वो वाला paragraph. Page number is 82.
नहीं ये वाला जजमेंट का.
अच्छा जजमेंट.
You place the judgment.
Yes.
मैटर तो आप ऑलरेडी प्लेस कर
हाँ,
चुके हैं. थोड़ा जजमेंट देख लेते हैं ना
बिल्कुल.
कि कैसे क्या करना है.
Yes. पहले इसका हेड नोट पढ़ दें या सीधे पैराग्राफ?
या पैराग्राफ पढ़िए.
पेज पैराग्राफ 22. It is not for the High Court to inquire into the question and decide whether the employment of contract labor in any process, operation, or in any other work in any establishment should be abolished or not. It is a matter for the decision of the government after considering the matter is as required to be considered under Section 10 of the Act. The only consequence provided in the Act where either the principal employer or the labor contractor violates the provisions of Section 9, 7 and 12 respectively is the penal provision as envisaged under the Act, for which reference may be made to Section 23 and 25 of the Act. We are thus of the firm view that in proceedings under Article 226 of the Constitution, merely because a contractor or the employer had violated any provision of the Act or the rules, the court could not issue any mandamus for deeming the contract labor as having become the employee of the principal employer. We would not like to express any view on the decision of the Karnataka High Court or the Gujarat High Court Supra, since these decisions are under challenge in this court, but we would place on record that we do not agree with the aforementioned observations of Madras High Court about the effect of non-registration of the principal employer or the non-licensing of the labor contractor, nor with the view of Bombay High Court. In the aforesaid case, we are of the view that the decision of the Kerala High Court and Delhi High Court are correct and we approve the same. Now this has since been followed in a recent judgment of 2019. The citation is 2019 7 SCC 440 and the paragraph is paragraph 48. It is true that judgment in Dinanath Supra is in reference to failure of compliance of Section 7 and 12 and not in reference to Section 10(1) of the CLRA Act. But if we look into the scheme of CLRA Act, which is a complete code in itself, non-compliance or violation or breach of the provisions of CLRA Act, it results into penal consequences as has been referred to in section 23 to 25 of the Act, and there is no provision which would entail any other consequence other than provided under section 23 to 25 of the Act.
In our case, the reference is under CLRA or it is under...
No, reference has to be always under section 10 of the... Yes, it has to be always. The reference will always be there like that.
Then why does it say section 10(1) of the CLRA?
Yes, 10(1) of the
CLRA Act?
That is, notification is issued under 10(1), prohibiting engagement of contract labor. Contract labor.
नहीं नहीं ठीक है, लेकिन हम वही सोच रहे हैं कि it is in reference to failure of compliance of such.
Yes, failure of compliance of section 10(1) notification. So in our case, the Labour Court has held that since the establishment was not registered under section 7 and the contractor did not have license under section 12, and therefore this would amount to camouflage.
ऐसा कहाँ बोल दिया?
Let us see that. Kindly come to page 82. Page 82 at the top. It will end next page. Thus, from the materials available on record, I find that there is reliable evidence to show that the concerned persons were engaged by the management for miscellaneous job related to production of coal due to shortage of manpower during concerned period. But in order to camouflage the matter, the management has made certain paper arrangement regarding showing them as contractor workers under the Pragatishil Shramik Sahyog Samiti. Management has not produced any document to show that the establishment of the management was registered under the Contract Labour Regulation and Abolition Act, nor they have filed any license of the contractor. Therefore, in view of the settled principle of law, as pronounced by the Honorable Supreme Court of India, in the case of Air India Statutory Corporation versus United Labour Union, reported in 97 Lab IC 365, in absence of registration of establishment of employer under Contract Labour Regulation and Abolition Act and license to the so-called contractor, the contractor labour must be deemed to be the workman of the principal employer. Therefore, in absence of any registration of the establishment of the management and license to the so-called contractor, the concerned persons may be treated to be the workmen of the principal employer, that is versus BCCL. Therefore, the concerned persons are the workmen of BCCL, and there is relationship of employer and employer.
You read further parallel.
Yes. Further, in view of the settled principle of law, as laid down in the aforesaid case of Air India Statutory Corporation, by the Honorable Supreme Court, when appropriate government has prohibited contract labour in any specified work, then management of contract labour on such work and creates relationship of employer and employee between the principal employer and the workman. The management witnesses themselves have admitted that stone cutting, coal cutting and tyndall work are prohibited category of job under which management of contract labour has been abolished by the appropriate government. From the work orders filed by the management, it appears that the cooperative workers, that is concerned persons, were engaged in the job of coal cutting, stone cutting, tyndall work, that is carrying off heavy machineries from one place to another, and even they were engaged in surfacing of coal with blasting, which also prohibited category of job, which cannot be performed by contract labourers. Therefore, in view of the aforesaid ruling of the Honorable Supreme Court, it has to be inferred that the relationship of employer and employee has been created the moment the concerned persons were engaged in prohibited category of job. The management has relied upon another Supreme Court judgment, which is popularly known as Dinanath's case, but that has already been overruled. The management witnesses themselves have admitted that under the Mines Act, it is the management which supervises the work of the concerned persons also. They have admitted that unless a person is competent and authorized by the management, he cannot supervise the work of even contractor worker into the underground mines. Therefore, it is persons were not gainfully employed from the period they were stopped work. And since BCCL is running in loss, therefore, the concerned person shall not be entitled. Now that judgment has been overruled as I submitted, and that judgment is before your Lordship also.
Let us see the part and to the extent it has been overruled.
Yes.
you can just refer to that specific paragraph of Air India Statutory Corporation, and then we can go to the sale judgment.
Our Steel Authority's judgment, Your Lordship, will come to para 120. Paragraph 125. Yes. The upshot of the above discussions is outlined thus. If we skip this, we come straight to paragraph 2A, my lords, on the next page. A notification under section 10(1) of the CLRA Act prohibiting employment of contract labor in any process, operation or other work in any establishment has to be issued by the appropriate government. After consulting with the Central Advisory Board or the State Advisory Board, as the case may be, and having regard to conditions of work and benefits provided for the contract labor in the establishment in question, and other relevant factors including those mentioned in subsection 2 of section 10. Inasmuch as the impugned notification issued by the central government on 9/12/76 does not satisfy the aforesaid requirement of section 10, it is quashed, but we do prospectively, that is from the date this judgment and subject to clarification that on the basis of this judgment, no order passed or no action taken giving effect to the said notification on or before the date of this judgment shall be called in question in any tribunal or court, including a high court, if it has otherwise attained finality and or it has been implemented. 3. Neither section 10 of CLRA Act nor any other provision in the Act, whether expressly or by necessary implication, provides for automatic absorption of contract labor on issuing a notification by the appropriate government under subsection 1 of section 10 prohibiting employment of contract labor in any process, operation or that or other work in any establishment. Consequently, the principal employer cannot be required to order absorption of contract labor working in the establishment concerned. We overrule the judgment of this court in Air India case prospectively and declare that any direction issued by any industrial adjudicator, any court, including the High Court, for absorption of contract labor, following the judgment in Air India case, shall hold good, and that the same shall not be set aside, altered or modified on the basis of this judgment in cases where such direction has been given effect to and it has become final. And 5. On issuance of prohibition notification under section 10(1) of the CLRA Act, prohibiting employment of contract labor or otherwise in any industrial dispute brought before it by any contract labor in regard to conditions of service, the industrial adjudicator will have to consider the question whether the contractor has been interposed either on the ground of having undertaken to produce any given result for the establishment or for supply of contract labor for work of establishment under a genuine contract, or is a mere ruse / camouflage to evade compliance with various beneficial legislations so as to deprive the workers of the benefit thereunder. If the contract is found to be not genuine but a mere camouflage, the so-called contract labor will have to be treated as employee of the principal employer, who shall be directed to regularize the services of the contract labor in the establishment concerned, subject to the conditions as may be specified by it for that purpose in the light of para 6. Now, para 6 is equally important. If the contract is found to be genuine and prohibition notification under 10(1) of the CLRA Act in respect of this establishment concerned has been issued by the appropriate government, prohibiting employment of contract labor in any process, operation or other work of any establishment, and wherein such process, operation or other work of the establishment, the principal employer intends to employ a regular workman, he shall give preference to the erstwhile contract labor, if otherwise found suitable and if necessary, by relaxing the conditions as to maximum age appropriately, taking into consideration the age of the workers at the time of their initial employment by the contractor, and also relaxing the conditions as to academic qualification of the technical qualifications. So this paragraph.
This paragraph number 4 says that it has been prospectively overruled.
Yes.
So any direction which has been given, that has to be respected.
Yes.
So direction is already there.
No, but it has not been implemented.
Not been implemented.
It has not been implemented. Your Lordship will also see.
Yes, I've seen that.
Yes, it has not been implemented.
It has not been implemented, respondent. You have not been taken into employment. You are out of employment. So there was any notification in connection with this establishment?
There is no notification for this establishment. But as I said, for the industry there is a notification.
Which is applicable.
Yes.
So your contention is that notification is
It's there.
applicable, but
But there
merely because there is a violation, they will not be entitled for any kind of job.
Unless it is a sham or camouflage. And the reasons assigned for
There is a finding that it is a sham and camouflage.
that finding is based upon the fact that the establishment was not registered and the license was not there with the contractor. And those two judgments which I have cited, Dinanath followed by this Steel Authority of India, 2019 7 SCC, they say that merely because the establishment is not registered or there is no license, it would not amount to camouflage. The consequences would be prosecution under 23 to 25.
That is not the only reason to say that it is a camouflage. Rather, the award says that they have been working, that
Yes,
finding
yes.
is there,
Yes,
they
yes,
have been working. They have been working and this society, the creation of this society, that cooperative society, that is a camouflage. That is the fact. Creation of this society is a camouflage to ensure that they are not treated as an employee of the BCC.
No, the society was awarded work, the society was being paid salary.
The finding is that the society was a camouflage. Creation of society was a camouflage.
No, that finding should not be perverse, it should be based upon some materials on record. Let us see that portion also. Again, we'll have to come back to page 82, Balance.
That's the only thing we
That is the only thing.
Thus, from the material available on them.
Yes, I find that there is reliable evidence to show that the concerned persons were engaged by the management for miscellaneous job related to production of coal due to shortage of manpower during concerned period. But in order to camouflage the matter, the management has made paper arrangement regarding showing them as contractor workers under Pragatishil Swayan Samiti. Now, this finding should be based on some material. Just saying that yes, you have been awarded contract to them, that contractor is being issued checks for payment of the work executed. Now, that does not mean that it is camouflage. Because therefore, thereafter they have said that you have no license and you do not have a registration and the contractor doesn't have a license.
This society does not have a registration.
No, yes, we are supposed to have a registration, the society will have to have a license.
So you do not have a registration.
I do not have a registration and he doesn't have a license.
Although the work is prohibited.
The work, I have said it is not prohibited. Your Lordship may take a view otherwise. Even if it is prohibited, that is 125(5). It says then it has to be, there has to be a finding that it has to be sham and camouflage, not otherwise. Still, even if it is prohibited, then subsection subpara 6 will apply. If that is the case, then in that case 125(6), as and when vacancy arises, then these persons have to be adjusted by giving preference, considering the length of service, or, and that is the reason I gave 2 judgments yesterday.
We need to rise today. We have a meeting. RBAT is complete right now. कल करें?
जब
कंटिन्यूटी में कर लेंगे, इनको भी सुन लीजिए. Heard the learned counsel for the parties, the matter has remained inconclusive. As the court time is over, close this case tomorrow for further hearing. At 2:15. इसको रखें. ये सब करना पड़ेगा.